A lot to discuss, Michael Popok. In the New York Attorney General civil fraud case, Donald Trump tried to do everything possible to avoid that judgment being entered. Interest accumulates every day. It's over $450 million, that judgment, and it is increasing each and every second. Tick tock, tick tock. Donald Trump unable to wiggle out of that one. We'll talk about the efforts by his lawyer. Also, in the E Jean Carroll defamation case, add another $83.3 million verdict on top of that. Let's cross that $500 million mark right there. Donald Trump was begging the federal judge there, Lewis Kaplan, now to stay the enforcement of the judgment there on an unsecured basis. In other words, Donald Trump does not want to post a bond in the E Jean Carroll defamation case. But Popok, didn't Alina Habba say he's got billions of dollars just hanging? He's got the cash just hanging out of his pocket. He's ready to post those bonds. When Alina Habba said he's ready to post the bonds, that was the moment I knew he does not have that money. Also, Donald Trump filed numerous motions to dismiss the indictment before Judge Aileen Cannon in the Southern District of Florida. Mar-a-Lago document case for Donald Trump's willful retention of national defense information. His co-defendants filed motions to dismiss as well. Donald Trump's motions to dismiss now are focusing on the fact that he did intend to take the documents, he claims. He says that they were his own personal records. He both claims that he telepathically declassified the documents and converted our nation's most sensitive information to his own personal property, and then claims he also has absolute presidential immunity for that. Not just frivolous, dangerous, and I want to get your take on it, Michael Popok, because he's essentially admitting to the crime that he intended to take this stuff. He's just claiming, yeah, it's mine. It's my personal property. Those nuclear codes, those war plans, they don't belong to you, American people. They belong to me. Why? Because I'm Donald Trump and I said so. Also, the United States Supreme Court has yet to rule on Donald Trump's application for a stay pending certiorari on Donald Trump's immunity challenge. Donald Trump was also claiming absolute presidential immunity in the Washington, D.C. federal criminal case. It's about 2 weeks since Donald Trump filed that application for a stay. We know that Special Counsel Jack Smith responded very quickly with his opposition. What is the Supreme Court doing? What does this delay signal? I mean, I thought that we'd probably get a ruling this past week, but it may be something we're okay waiting for if we read the tea leaves the same way. I want to get Michael Popok's take on that. Also, Alexander Smirnov talking not about takes, but tasting prison cells right now. You got Smirnov, who was there. I've never actually seen a photo of what this Smirnov guy looks like. That's the closest that we've come right there. This was the star witness for the MAGA Republicans in the House of Representatives, who actually turned out to be an agent of Vladimir Putin and Russia. How do we know that? He's admitted to it. He says that he was basically taking orders at this point. There was a whole thing where he was arrested in Las Vegas, and then there were proceedings in Nevada, and then there were proceedings in California federal court right here in Los Angeles. We'll break that all down, what's going on there. And then I do want to talk about this Alabama IVF ruling, its implications as well, where the Alabama Supreme Court has all these MAGA Republicans. This is what MAGA Republicans have been pushing. This has been their consistent policy. They've declared that frozen embryos are children, such that if anything happens to a frozen embryo, you could be charged with murder. And now you have MAGA Republicans out there and Republicans recognizing how unpopular this position is. And they're like, now let's fix it. Y'all created the problem. Y'all are creating all of these problems. This was your plan. And just like the way you overturned Roe v. Wade in the Dobbs decision, it has lots of ripple effects throughout our system, including with this Alabama court ruling. Michael Popok, this is Legal AF. A lot to discuss, a lot to break down. I'm glad to be doing it with you, sir.
You too, my friend. So let's summarize. Trump is busted financially. The sneaker sale apparently didn't go as well as he thought. We'll talk about that. He's dead in the water when it comes to the trials that are coming up. He wasn't able to avoid the March 25th start of the Stormy Daniels trial. We'll talk about it, avoid the May Mar-a-Lago case. But I think, and you and I will handicap this, I think that Chutkan's trial will be back on DC election interference sometime over the summer. So he'll have 2 trials under his belt, busted and out of money, while Republican policy is exposed for what it is, anti-family, in the Alabama decision and its aftermath.
And this is where it's the intersection of law and politics, as we always like to say, because a lot of this political agenda that's been pushed over time by MAGA Republicans, they've been relying on this kind of, I think, lack of public awareness of just the way the system works. Putting judges into power in certain places, pushing agendas that override what people actually, want and need, and pushing these agendas. But that's why it's so important to make all of this info accessible to everyone. And that's one of our goals here at Legal AF when we break everything down. So first and foremost, let's just talk about the E Jean Carroll case, where first we had Alina Habba go on her right-wing media tour. She was asked from everyone from Hannity to Newsmax, so does Donald Trump have the money? Does Donald Trump have it's going to be $400 million, $450 million. It's every day it's increasing more than $100,000 with interest, but we're in excess of $450 million that Donald Trump would have to post a bond for. And she said he's got it. No worries. He's super rich and he's ready to do it. But his actions in the courtroom, as we frequently see, are very contrary to what the propaganda is that's out there, even if the propaganda is idiocracy. So what was happening in the court proceedings as well is that Donald Trump and his lawyers wanted to kind of challenge the submission of basically a basic judgment form, right? And Popok, you'll take us through the process here, but basically, in New York, you get a decision and order. That's what happened first. That's the 92-page filing, decision and order. But that has to be basically put into a form, a judgment, so that when you have to enforce the judgment, whether that's seizing property or seizing bank accounts, you show a literal judgment. You hold it up and you go, look what I got. Here it is. Here's the judgment bank. Let me get into his account. Here we go, sheriffs, let's seize the property. And it should be a pretty basic copy and paste job, right? The last 2 pages of the 92-page order have basically the relief. You take that, you plug it in, you add some interest, and it's as simple as that. But Trump's lawyers wanted to object to that. They wanted to settle the order. And then the judge and New York Attorney General Letitia James like, what do you mean settle the order? Are you trying to negotiate? What are you talking about? So let me pass it off. I'll give you the handoff there, Popok. What happens next?
Yeah, as a New York lawyer. Yeah, you got it exactly right. The D&O, the decision and order, and I get dozens of them in my cases in New York, is the memorandum decision. It's the underpinning, the analysis. But you can't take that to the sheriff. Sheriff goes, where's your judgment? So every case, and this is not just in New York, this is in every place, whether you call it I don't know exactly what it's called in California, but the memorandum decision, the decision and order, whatever it is, it's the legal decision. We call it the D&O in New York. But then you have to convert that, usually relatively quickly, with a judgment. Sometimes a judge will tell one side or the other, draft the proposed judgment for my review. Sometimes he'll say in New York, settle order, meaning you guys get together and try to do one agreed upon order and submit that for my review in Word version in case I want to make a change to it. And if you can't come to an agreement, then submit competing orders. The judge didn't say anything, so it was up to the parties to do that. If I were Trump's lawyers, it's always hard for me to say that phrase. If I were Trump's lawyers, almost immediately, I would have taken the shot, because now you got one more shot at a little bit of advocacy and maybe getting some verbiage and some language that may be helpful to you that you can actually get this judge to agree to, even though the fundamentals have to match the decision and order on the award. So, but they abdicated. They're once again asleep at the switch. They abdicated their role in helping to shape and craft the actual judgment. And instead, they lobbed in these emails and these letters, usually through Cliff Robert. They use different people for different things. Alina Habba, we'll talk about next in the E Jean Carroll case. Cliff Robert's the one that's trying to be the New York lawyer doing hand-to-hand combat with the judge and others on procedure. Judge, we need more time. The order, the judgment came in from the New York Attorney General. We didn't get a chance to review it. That's not the procedure. We're supposed to talk about it in advance. Give me 30 more days, which is always the transparent, attempt to delay. Why are they trying to delay? And it didn't work because the judgment got entered, basically exactly the format that the New York Attorney General submitted. Trump should have submitted a competing format and then argue for maybe some of the fine points. There was a little screw up in the calculation of interest as to Alan Weisselberg's separate judgment or embedded judgment, and that got resolved. But everything else was, as you said, sort of a form that follows the remedies and recites the grounds that are listed or reincorporates the grounds that are listed in the D&O. So the reason they were asking for the delay, and we'll talk about delays here a lot, is that until the judgment is entered and docketed by the clerk, the timeline, the timer for appeal doesn't start to run, nor does, now prejudgment interest continues to run, but the timer for the appeal doesn't run that 30-day period. And then posting the bond doesn't really start to run until that judgment is in place. And we can see, as we'll talk about in the next segment, they don't have the money. And it's very hard, even for a multi-billionaire, self-proclaimed, to scrape up $500 million for two different cases and post the bonds appropriately. Despite the false bravado that you mentioned of Alina Habba bragging about, we got the money, we'll post it. Well, apparently they don't, because they're constantly asking for delay. So the judge already entered that judgment, which means now, unless he goes and posts his stay bond, the New York Attorney General can levy on assets. Now, this is even easier, as you and I have done in Hot Takes. This is even easier than in the normal judgment creditor, judgment debtor scenario. For the first time ever at this amount, an ex-president is a judgment debtor in the amount of $500 million, running at $3.4 million a month in accruing interest until he pays that judgment and or wins on appeal. So they, as a judgment debtor, on the other side is the judgment creditor, which is the people of the state of New York that are embodied by the New York Attorney General. She's got creditor's rights. That's what I practice, a part of my practice. And under creditor's rights, she could normally have to go find assets. You have to go, you have a piece of paper, we call it a paper judgment, but to convert it into cash, you got to go find the assets. Sometimes that's difficult, but not here, not when there is a monitor in Barbara Jones that has been responsible for keeping an eye on and inventorying all of the assets of Donald Trump, whether they were in his trust, they're in the Trump organization, any of the 50 affiliates, or personal, any of it. She knows exactly where it is. So all Letitia James has to go is, please hit print, Miss Monitor, and give me all of the bank accounts and bank account numbers and all of that. This is easy. Now, once you have the judgment, you can collect up until the amount of the judgment. You can't get more. You can't over collect. But let's say they grabbed, 40 Wall Street. Sheriff shows up, puts a padlock on it, and sets it for public sale, which is now done really electronically. Let's say the building goes for $250 million. I'm making up numbers now, right? The market's going to tell you what the building's worth. Now, the bank that still has the loan, I think it's Deutsche Bank, or it's actually in a commercial facility, somebody will show up and credit bid the amount of their bank loan so they don't lose the property for less. So then the bank will end up probably owning it, but they'll have to pay in the amount of money at the difference. So whatever she collects it deducts from the amount that's owed. Donald Trump's got to scramble to get this bond in place. If he doesn't have the cash, which apparently it looks like he doesn't, and he's buying time, he's going to have to liquidate assets, which has to go through Barbara Jones to approve effectively, or he's got to get a bonding company that's going to lend him $500 million on his personal credit. And his personal credit is completely in shambles because he's been judged a fraudster and somebody whose personal financial statements are just completely made up. And assets that, I can tell you straight, bonding companies hate real estate because they have to sell it and liquidate it in the market. They hate it anyway, but they certainly hate Donald Trump's assets because they're all fugazi. They're all made up numbers, and there's no true appraisal backing up any of these things. We're gonna watch with glee Donald Trump scrambling to try to figure out how to rob Peter, to pay Paul, to pay these bonds, and to post them in all the judgments that we're going to talk about on this show.
And ultimately what this could actually do and stay very close to this story is expose what Donald Trump wants to hide the most, that he doesn't really have the cash. And that is going to, I think, be the bigger story. Like, is he going to have to declare some sort of bankruptcy to try to delay the process? By the way, it's a fraud judgment, so it's not a dischargeable debt in bankruptcy, although you could try to delay the time by initiating kind of bankruptcy proceedings. But is he going to try to do that? One interesting thing I noticed, too, in the back and forth with these letter briefs that were being submitted to Justice Engoron, that I was like, is Trump's lawyers trying to pull another scam here? I don't know if you caught this, Popok, but in the letter, Donald Trump's lawyers almost acted like there was a ministerial error in the proposed judgment and just said, oh, it just looks like you got the address wrong of about 6 or 7 of these Trump-related entities. You say that they're based in New York. I just want to correct it. It should say that they're in Florida. And here's the page of the filing right here where they do that. They talk about the Donald J. Trump Revocable Trust being in 1100 South Ocean Boulevard, not at the Park Avenue address. DJT Holdings being in Jupiter, Florida. DJT Holdings Managing Member LLC, Trump Endeavors, and a few other entities like that. And then the New York Attorney General's office's lawyer said, no, these are New York companies. What are you talking about? We're not changing the address right now. That's the letter from the special counsel who works with New York Attorney General Letitia James right there. And then the judge just basically responded, you're not saying anything that makes me change in any way the judgment. This is what Justice Engoron wrote. Dear Mr. Robert, referring to Donald Trump's lawyer, you failed to explain, much less justify any basis for a stay. I am confident the appellate division will protect your appellate rights. Signed, Justice Engoron. And then the judgment was entered, shortly thereafter.
Yeah. On that note, Ben, before you go on, the reason there's all this, there has to be magic language that's included in judgments. The law is very specific about notice to creditors and debtors, and so but like you said at the top of the podcast, it's a form. You have to make sure, and case law sometimes changes what judgments have to look like in individual states. New York did a whole update a couple of years ago and some new case law that came out. But you got to make sure the judgment debtors' addresses are properly listed, the time, and when the judgment interest starts to run. There's a whole bunch of things that have to be included. But she got it right. The New York Attorney General got it right, and they knew she got it right, and they knew there was very little of anything they could do. But as you said earlier, or you've said throughout the podcast history of Legal AF, this is all about delay. They know they're going to lose this. They know they're going to lose it at the appellate division, first department, which is the first level of appeal they're going to try to take. There's no way they're winning this. That appellate division has already ruled 3 times against Donald Trump on this very case. They are not going to suddenly think that Judge Engoron has not done the right thing in his 92-page of analysis. And then the Court of Appeals in New York there's no way he's winning that. And that's it. That's the end of the road. There's no, for people that, follow lightly our explanations, there is no federal switch over here. We're not getting to the United States Supreme Court. This is going to stay hermetically sealed in New York state practice, and that's it. Now, it could be tied up in appeals for the next year, but he's got to post that bond in the meantime. We'll talk about what they're trying to do in just a very small amount of money comparatively, the $83.5 million for E Jean Carroll, what they're trying to do there with delaying the posting of the money, which indicates to me that they're out of cash. But this is not about them ever thinking they're going to win and defeat Judge Engoron. This is only about when bad things are happening, make them happen slower.
One of the reasons I think they were also trying to, in a very kind of tricky sleight of hands way, change the address to Florida addresses was then claim if those properties were then going to be seized by the New York Attorney General's office to claim that there wasn't jurisdiction, and then you would have to initiate a separate action in Florida to enforce the judgment and to try to delay and tie it up more. Remember, back in 2022, Donald Trump initiated a lawsuit in the state of Florida that got removed to federal court against New York Attorney General Letitia James, trying to claim that the situs of the trust and therefore all of the other assets that fall under the trust were in Florida, and then get an injunction to block the lawsuit. So it seemed to me also at the last minute right there, kind of a bad faith scheme that was easily smoked out there by the lawyers for
on that last point. And you remember just to wrap that out, he tried that. He tried to get Florida to intervene on his behalf for the trusts until Letitia James, as you said, removed it to federal court, and it got assigned to Judge Middlebrooks, who had already sanctioned him and Alina Habba over $1 million for their phony lawsuit against the DNC and Hillary Clinton. And he wrote them, if you remember, man, we did a whole hot take and we did a whole legal app on it. He wrote them and basically said, you may want to reconsider this lawsuit. I'll give you a short amount of time to withdraw it. And suddenly they withdrew it.
You want to know the biggest tell that Donald Trump does not have $500 million in cash to post as a bond? Maybe because he's selling fascist clown shoes for $399. I don't exactly see real billionaires going out there and selling clown fake red bottom shoes out of the back of their truck in order to try to make a few bucks here and there. But we'll save that political analysis for other Midas Touch hot takes that I may or may not do. But another major tell is another filing that was just made at the end of last week by Donald Trump's lawyer, Alina Habba. They also brought in John Sauer, who has that kind of soury, raspy voice. You probably have heard him in the appellate arguments before for Donald Trump in the various cases. And one of the things that was just filed was this memorandum of law in support of the motion to stay execution of the judgment pending disposition of the post-trial motions in the E Jean Carroll case on an unsecured basis. Basically saying to Judge Lewis Kaplan, I'll just read from the it says, pursuant to Rule 62 on page 1 right here too, of the Federal Rules of Civil Procedure and this court's equitable authority, defendant, and they always refer to him as president, Donald J. Trump respectfully requests that this court grant an unsecured stay of the execution of the court's February 8th, 2024 judgment. So they're going to federal judge Lewis Kaplan, who presided over the E Jean Carroll defamation case, where Donald Trump was found liable by a federal jury for defaming his rape victim. Donald Trump was defaming his victim in the courtroom itself during jury selection and throughout the proceedings, which the jury saw him doing. Donald Trump was also attacking federal judge Lewis Kaplan. Now, Michael Popok, Donald Trump's out with his hands out playing the victim, saying, federal judge Lewis Kaplan, please help me. Please stay what the jury is doing. on an unsecured basis so I don't have to post a bond, because I think the punitive damages was way too high against me, and so was the compensatory damages and the reputational repair damages. And so please don't make me post a bond. We get along well, right, Judge Kaplan? Popok, how pathetic is that?
I don't know. Pathetic. I don't know who is a better, more who's a better legal writer, Judge Engoron or Judge Kaplan, in two separate court systems against Donald Trump. I don't know which one has the more withering pen between them, but I can recall, if we're looking for a dress rehearsal for this motion filed by Alina Habba, again, yes, joined by what appears to be, what I think will be their appellate counsel. We're always wondering who's going to take these appeals for Donald Trump. Looks like John Sauer has stepped up, got the short straw, and will be handling the appeal on this case. And she's added their name to the brief. They're not admitted yet into the Southern District of New York, so their admission is pending. But in their request, what I brought me back to was the very same thing that they attempted at the core, which is they're arguing to the judge that based on motions for remittiture, which is asking the court to use its equitable powers and inherent authority to reduce substantially the amount that the jury awarded, because they're going to argue that the jury's number of $83.5 million, or almost 4 times the compensatory damages that they awarded her. I think it was like 17.5 of compensatory damages, and then the rest was punitive damages, that ratio between punitive damages and compensatory damages based on a series of cases is too high, that it should be anywhere between, they're going to argue, between 1 times your compensatory, so just 17.5 million, or maybe 2 times, but not 3.5 to 4 times. And they're going to ask the judge to take his red pen, his blue pencil, and lower the number before they have to deal with it on appeal. They tried this the last time on the remittitor part. They tried this the last time with the $5.5 million judgment when Donald Trump decided to stay in Scotland and let Joe Tacopina lead the case against E. Jean Carroll, and they lost that case as well. Because the number was lower, I presume they didn't ask to have the bond stayed, and they posted that bond in cash. It's always another telltale sign of a problem, in cash with the court clerk as a bond. But they also made the remittitor lower, please judge, lower the number that the jury, it should be closer to 1.5, I think is what their argument was at the time. Same thing here, except now they've coupled it with, because we're likely to be successful, judge, on convincing you that you should lower the number by like 75%, that's the bond amount that we should post. We should just post like 22 million or $24.5 million, and that's enough. We should never post anywhere over the 83.5. That number is completely made up, has no merit, and you're going to reduce it. And if not, we're going to win on appeal. All right, good luck. I could write already. You and I could probably mimic Lou Kaplan's response, having seen dozens of his orders in the 2 cases already. And it's going to be similar to what Judge Engoron did, which you put up before, which is, you've given me nothing but rhetoric. Your case law analysis is wrong. The jury has spoken. It's well within the range of permissible punitive damage ratio between compensatory and punitive. And so the answer is no. And I'm not going to let you have a temporary administrative stay without posting a bond, which is what they want. They want it on Alina Habba's letterhead without having to post the money. What are we watching again? They don't have the money, and they don't want to. And every day they get Lewis Kaplan to delay this is one more day they have to go scramble to get the cash. Because if they don't get the cash, then that whole description that you and I gave about what a sheriff does with a judgment in their hand is going to be Robbie Kaplan, the lawyer for E. Jean Carroll, and we know where all the assets are, and knocking on the door and taking bank accounts. I mean, literally turn over the money, turn over the car, turn over the Trump Tower, the triplex. Maybe she owns the triplex when this is all done at a sheriff's sale. The other thing I thought was the height of being disingenuous, but not surprising coming out of Trump world and Alina Habba. But Robbie Kaplan will make her pay, and it will be part of Lewis Kaplan's rejection of this motion, is where they completely ignore that there's now a $550 million judgment running against Donald Trump that he's also trying not to pay, with interest running at that $3.5 million a month. Because they say, well, even in the trial, the lawyer for E Jean Carroll made a big deal that there's more than enough money in my client's bank accounts to pay for the judgment. So under the factors that you use, Judge, about whether there's any chance that the judgment wouldn't be paid as a condition of the bond, we have a lot of money. You do? You're not paying the $550 million. She doesn't mention that there's now a huge judgment against her client that we have no idea how he's going to pay that. And Robbie Kaplan is going to make her pay what you and I would have done. Again, every time, let me make it clear to our chat group, we'll never represent Donald Trump. And we're not giving them things that they're going to think of. So don't worry about that. They're beyond help or remediation. Don't worry about Ben, me, or Karen giving them ideas that they're not going to grow a brain overnight. So don't worry about that. But if we had the case, we would have at least tried to take the sting out of that, at least in a footnote, and said, yes, there's a $550 million, but he has $3 billion, and don't worry about it, and we're fine. No, they don't say that, and they don't support it with any sworn statement or declaration or affidavit from the people that have the money, right? Like Barbara Jones keeping an eye on everything, or Donald Trump himself. It's all naked rhetoric and argument of lawyers without any support whatsoever. And this is it's going to be rejected, but you and I are going to have fun reporting on Robbie Kaplan nailing them, counterpunching them to death about Donald Trump and his cash.
And look, I just want to be clear here that it's not just we attack all of Donald Trump's lawyers because they're Trump's lawyers, and that's what we do on the Midas Touch Network. If you'll recall, when Donald Trump's lawyer, from just a lawyering perspective, made the arguments on the 14th Amendment Section 3 case before the United States Supreme Court, my hot takes were, I totally disagree with the legal arguments, but I thought that was a great lawyer. Just the reality, who was it was a strong, like great, maybe a little bit hyperbolic, but it was a strong lawyer, I thought, representing Donald Trump, who did something strategically, like what Michael Popok just suggested in a footnote in that case. Remember, Trump's lawyer, to Trump's chagrin, and this is why Trump can't have good lawyers, because he'll always go after them and attack him. Trump lawyer said, look, January 6th was criminal. It was a riot. It was a horrible day in our nation's history. But members of the Supreme Court, you should not use that to, in terms of your rubric for how you rule. I'm paraphrasing there. But I think when you make concessions like that, you build more credibility in front of courts on very difficult cases. So that's just from a legal strategy perspective. We got a lot to discuss, including Donald Trump's frivolous motions before federal judge Aileen Cannon. That's how you don't build credibility, when you claim that you had the absolute right to steal national defense information and convert it into your personal property. But then again, it's before Judge Aileen Cannon. Let's talk about that. Let's talk about what the Supreme Court's doing. And let's talk a little bit more about the Alabama Supreme Court ruling. The ripple effects are being felt throughout our nation. It's important we address it here. We'll be back after this quick break.
Ever wonder how much of your personal data is out there on the internet for anyone to see? More than you think. Your name, contact info, social security number, and home address, even information about your family members, all being compiled by data brokers and sold to the highest bidders online. Anyone on the web can get your private details. This can lead to identity theft, phishing attempts, harassment, and unwanted spam calls. As a podcast host in the high-profile U.S. law and politics space, I've received a bit of every one of these personal data breaches. But now you can join me and protect your privacy with Delete Me. With over 40 million views of my content a month, my personal data and info is searched for not just by our Legal AF audience, but by trolls and bad people with ill intent. And I got a family here and abroad to protect. I know that my personal data has been breached in the past and fallen into the wrong hands, who don't appreciate our message or want to silence us, including death threats and threats of physical harm. And that's why I personally use Delete Me. Delete Me finds and removes any personal information you don't want online and makes sure it stays off. Delete Me is a subscription service that removes your personal info from the largest people search databases on the web, and in the process, helps prevent potential ID theft, doxing, and phishing scams. Sign up and provide Delete Me with exactly what information you want deleted, and their experts take it from there. Delete Me sends you regular, personalized privacy reports showing what info they found, where they found it, and what they removed. Delete Me isn't just a one-time service. Delete Me is always working for you, constantly monitoring and removing the personal information you don't want on the internet. Take control of your data and keep your private life private by signing up for Delete Me. Now at a special discount for our listeners. Today, get 20% off your Delete Me plan when you go to joindeleteme.com/legalaf and use promo code legalaf at checkout. The only way to get 20% off is to go to joindeleteme.com/legalaf and enter code legalaf at checkout. That's joindeleteme.com/legalaf, code legalaf. Heart health and staying healthy, especially when you have family, friends, or loved ones that you'll want to be able to spend as much time with as possible, is so, so important. February is Heart Health Month in the United States, and more than half the population would still benefit from blood pressure support. Super Beats Heart Chews are the #1 doctor, pharmacist, and cardiologist recommended way to support healthy blood pressure. And they even promote heart-healthy energy without the stimulants. Paired with a healthy lifestyle, the antioxidants in Super Beets are clinically shown to be nearly 2 times more effective at promoting normal blood pressure than a healthy lifestyle alone. And with over 40,000 5-star reviews and counting, people are raving about Super Beets Heart Chews. Super Beets Heart Chews are absolutely delicious and are truly much better than any alternative supplements out there. After taking my Super Beets Heart Chews, I feel like I have more energy and I'm ready to take on the day. Super Beets is the #1 doctor, pharmacist, and cardiologist recommended heart chew for cardiovascular health support. It's blood pressure support you can trust. Support your heart health with Super Beets Heart Chews. Get a free month supply of Super Beets Heart Chews on all bundles and a free full-size bag of turmeric chews valued at $25 with your order by going to legalafbeats.com. Get this exclusive offer only at legalafbeats.com.
Some great pro-democracy sponsors right there. I mean, that Delete Me one is incredible. And given the nature of the work we do, I can tell you that's very important for us right there. And then I get a lot of messages from people about the products that Jordy vets and that we really like here. One that I get a ton of thank yous for are those Super Beets Heart Chews right there. So I take them every day, or I chew them every day. They're actually very tasty and make me feel great. Just want to, and we get a ton of positive feedback about them.
This is going to sound stupid because I should have been interested in my health even before. But as people know, I've got a future growing family here, and my wife's on a whole bunch of vitamins and other supplements, and I've gotten into it. And I'm so glad that Super Beets Heart Chews is part of it because it does help. I'm older than you. It does help with things like blood pressure and that type of thing. And the Delete Me one, I got my first Delete Me private report that comes from having that membership, and it was eye-popping. I'll just leave it at that.
Exactly. Yeah. All right, let's get into what's going on in the Southern District of Florida case. That's the federal criminal case against Donald Trump for the willful retention of national defense information, as well as obstruction of justice. Judge Aileen Cannon did not give Donald Trump an extension to adjourn these pretrial dates and deadlines. So Donald Trump had to file them at the end of last week. Donald Trump requested the ability to file a 200-page omnibus motion to dismiss indictment, which Judge Aileen Cannon also rejected and said, no, you could submit, 10 separate individual motions. Some of them were on the public docket. Some of them have not hit the public docket because there's major redactions to them. So the ones that we do have, though, Michael Popok, just show how kind of extra frivolous there are. There's about like 10 of these motions to dismiss that Trump filed. Also, his co-defendants kind of filed ones as well, somewhat pointing the finger at Donald Trump, saying that they didn't really even know that these were classified documents and they were just following instructions to move boxes around, and therefore the co-defendants claim they don't have intent. But Donald Trump's essential argument, when you combine two of his main motions to dismiss, one was a motion to dismiss based on the PRA, the Presidential Records Act, which Donald Trump claims he can declare anything at all to be personal records. He can take government records and just say they're personal, when the Presidential Records Act like expressly states you can't do that. The whole purpose of it is so that you don't declare presidential records as belonging to you. But Donald Trump's approach to this is to say no, what it really means, because Trump's getting his advice from a guy named Tom Fitton, who's not actually a lawyer, who runs the far right-wing group called Judicial Watch, is that he can declare anything. Nuclear codes, war plans, military secrets, you name it. If Donald Trump telepathically declassifies and telepathically believes it's personal and puts it in a box, Donald Trump's argument, it is therefore his. And then he kind of layers on this another motion to dismiss, claiming absolute presidential immunity. And if he does the telepathic declassification and telepathic conversion of our government secrets and records into personal property while in office, then Trump says it falls within the outer perimeter of his official presidential responsibilities and therefore can do whatever he wants with them. I hearken back to what Special Counsel Jack Smith put in some of those briefs in the Washington, D.C. case, where Special Counsel Jack Smith said, look, under Donald Trump's logic, you could sell nuclear codes and military secrets to foreign nations and claim it's foreign diplomacy. And then I go back and think about some of those meetings that Donald Trump even had in 2017, May, when he met with the Russian leaders who showed up at the White House. People forget he shared military secrets with the Russians when they were there, and then he posted on social media, then Twitter was called, now it's called X, Twitter then, that he had the absolute right to do that. So you think about what he's arguing here now in this motion, that he's saying that, yes, I had the mens rea, I had the intent to withhold the national defense information, right, Popok? Those are all the elements of the crime, but they're mine. Those nuclear secrets, they don't belong to you, government. They're me, and those war plans, the stuff about Iran, mine. You think those are the government? They belong to me. You can't do anything about it. It's such an outrage, Michael Pope. I mean, you can't get more of a despicable argument. And then I see Axios post, President Biden uses note cards occasionally when he talks, like every politician. So your front page story, Axios, is how President Biden uses note cards. And meanwhile, and I won't even get into Donald Trump's speech at this Black Conservative Federation thing that I've done videos about and all of his other traveling fascists. I'll save that for my political takes. For my legal take, he just filed a motion claiming that he can steal our nuclear secrets and say it's his. And I don't see that on front page. I don't see it on any pages. I see it here on the Midas Touch. It's an outrage, Michael Popok.
Yeah, it is an outrage. By the way, we all use notes. Here's mine for the show. Okay, on every topic. I mean, it looks extemporaneous, but sometimes when Ben's talking, I'll look down and see if there's a point in particular I wanted to make for the show. I like a president. My takeaway from her report was not that our president's in his dotage. My takeaway was, look how organized he is. He's been doing diaries and binders of every meeting he's ever attended since he's been in public office. That's a good thing. And contrasting that with Donald Trump, who they stopped giving the presidential briefing to because he was too bored, uninterested, or too stupid to get the presidential briefing, daily briefing. That is the contrast that we have here, and why people run stories about him using notes. I'd be shocked if a president went up to a podium and didn't use some sort of notes to handle all the things he has to handle. Now, putting that aside for a minute, the four motions that you talked about that we know about, two of them are just completely frivolous and ridiculous. This is the same thing that they had to do, as you mentioned, Ben, with Judge Chutkan in the D.C. election interference case. They had to do, I think it was 4 or 5 then at the time. And one of them is, special counsel was improperly appointed. Can only go through the Senate. That is completely wrong. And every court, including up to the Supreme Court, has recognized the procedure, implicitly or expressly, the procedure that Merrick Garland has used for the appointment of the special prosecutor, so that he's invalid. And they don't even call him special counsel Jack Smith. At one point, they just call him Jack Smith. Jack, like he's some sort of, action hero, that Tom Cruise is going to start playing soon. Jack Smith can't, he's improperly appointed. Therefore, everything he does is invalid. Wrong. Then they didn't like that. So they said, let's do one on appropriations, as if they understand the appropriations clause or process under Congress. His budget, he shouldn't be spending taxpayer dollars chasing after me. Okay, that's even in the hands of Aileen Cannon, who you and I may differ about some of her actions. We all agree that she is not reliable in terms of her decision making, and we can go further as we continue on this segment. So those two forget those. That's just chaff that they threw up just to throw spaghetti at the wall, hoping that Aileen Cannon would give them something. The last two is, one, they had to do, even though it's brazen, they just lost presidential immunity on a similar argument with similar lawyers in front of the D.C. Three-judge panel of the D.C. Court of Appeals. And we'll talk about it coming up next, about what we're waiting on with the United States Supreme Court, whether they're going to leave it undisturbed or they're going to overturn it. But they already lost. Now, that is one circuit among a total of 12, including the D.C. circuit. So you can try to invite a conflict between the circuits, even while the Supreme Court has not yet ruled. And that's what they're doing. I mean, I give them an A for consistency or a C for consistency. They're like, well, we got to keep going with this immunity thing. No person really believes that Donald Trump's lawyers even believe that they have a winning argument on immunity at all. This is all about delay. And if they can get Aileen Cannon to make a bad decision again, and they have baited her in the past successfully into making bad decisions, starting before the indictment even came out, in how she interfered with the investigation and the search warrant, bad decisions leading to her getting reprimanded twice by the 11th Circuit Court of Appeals. She just recently made a bad decision, totally against the weight of the law, clear error, and manifest injustice, as we like to say in the appellate world. And now she's going to have to that just happened a week ago. So they know if they pressure Aileen Cannon, because she doesn't have the experience and her judgment seems to be slightly off kilter, her initial instincts don't seem to be there, they can get her to make a bad decision that they'll just deal with delay in time at the 11th Circuit. So the two you talked about, yes, immunity. There's no way he has immunity from Espionage Act violations, right? Because you can at the same time be a president and have committed Espionage Act violations if the indictment makes that out. And I'm going to talk about the indictment procedure for a minute here next. Then, so they don't like the Espionage Act. They don't like the way it's being applied to Donald Trump. Oh, it's constitutionally vague as applied to the president of the United States, because he's got these other duties under the Presidential Records Act that he also violated. But the heart of the case is not the Presidential Records Act, which is not a defense to a criminal case. The criminal case against Donald Trump at its heart and soul is obstruction. That's why when they appointed the special prosecutor, special counsel, Merrick Garland said the word obstruction more than half a dozen times and never said the word Espionage Act, because the case is about obstruction of justice and all the things that lead to that, and conspiracies around obstruction of justice. That's the box moving. That's the hiding the documents in the boxes from his lawyers, not just Evan Corcoran, but also from his lawyers that were initially negotiating with the National Archive. It's the obstruction of misleading your lawyer, so he misleads the Department of Justice and the special counsel and the FBI, while people that worked in and around Mar-a-Lago, like housekeepers and maintenance people who cooperated and executive assistants, all said, there was a lot of box moving going around at the very moment when the boxes should have been turned over without objection to the National Archive. He should have just turned, if he took it by accident, which is sort of the Joe Biden Robert Hur world, he didn't do it on purpose to the extent of criminality, wanted it for other purposes. He thought his diaries were fine. That's Joe Biden. If he did it by accident, then when you get your first demand from from the National Archive, you turn them back. And let them figure out if there's personal items to send back to you, not the other way around. But that's obstruction. So their argument that the Presidential Records Act somehow presents a defense to obstruction is ridiculous, and that is not going to be the law. Or that he had classified security clearance, Q clearance at the Energy Department level in order to keep the nuclear secrets. That's completely wrong as well. And we've seen people, and we've had them on our channel, that walk through the proper national security clearance need to know basis analysis, and he fails that as well. So that ain't going to work. One commentator I like said on one of the YouTube channels, oh, now we're just going to have Kash Patel get up and talk about the magical declassification that nobody saw and nobody wrote about at the time they left the White House. That's going to be his defense. Good luck. Even a North Florida jury, which kind of trends a little bit towards Trump politically, would convict him if that is going to be his main defense. But the reason none of this is going to work doesn't matter to Donald Trump, because his goal here is not to win on any of these. His goal is what we're watching, which is the delay. And so the reason you and I are talking on late February, almost March, about an indictment that was presented a year and a half ago, this whole thing is about what the indictment says, not what the 1 trillion pages of documents that have been delivered in discovery say, not the whole fight over SEPA, the classified information case. It's none of that. This is about the 40-page indictment that came out a year and a half ago. If they had the grounds for any of this, it should have been raised 8 months ago. And you and I should have been talking about motions to dismiss at the same time we talked about the motions to dismiss the DC election interference case, which happened around the same time. But that's when Judge Chutkan had the case, and she said early briefing, this one, Aileen Cannon, let this go to 2 months before the trial to talk about the dismissal of a piece of paper called the indictment. What does that have to do with anything? Because here's how it's going to work. She's going to set a briefing schedule. They've asked for oral argument. There's going to be 2 more briefs that have to be filed. She's not going to accelerate a darn thing. And this thing's going to stretch out through the entire month of March. She's going to make a ruling in April at best. There's going to be an appeal level up to the 11th Circuit that's going to take us over the summer. And so bye-bye trial date. And we're going to know, Ben, because on Friday, there is a hearing in front of Judge Cannon where she's going to basically say that trial in May is over. And we're going to get either a new trial date or an indefinite postponement. And that's exactly what Donald Trump has wanted. He's got his group of trials that he's tried to torpedo one by one. And he's gotten so far, he'll get this one off the board before the election. He's pinning down right, wrong, or indifferent, Fani Willis, and the setting of that trial in Georgia based on the charges against her. He wasn't able to stop the Stormy Daniels business record fraud case, which is going to trial, as you and Karen especially predicted would happen by the end of March. That submarine case that's now the #1 case going to trial. And now what we're going to watch and carefully hear right here on our network is going to be this hand-to-hand combat to see if we can get the Chutkan case back up and running by the summer, depending upon what the Supreme Court does next.
Well, look, there was never going to be 4 cases that could just actually fit in, just the spacing of it before the November 2024 election. Just not possible for that to even take place, at all, unless there were overlapping trials, which would not be the case because Trump has to appear at these criminal cases. So, the thing is, if there are 2 that do take place, and the 2 that take place is the Manhattan District Attorney case and the Washington, D.C. federal criminal case for overthrowing the results of the 2020 election or attempting to, those are the two that I'd like to to have seen. And I think Trump will have made a massive strategic blunder not to put the case first before the one that's before Judge Aileen Cannon, who's his preferred judge, who bends over backwards, who likely in jury selection and all of these other things would have been helpful to him, but also filing all of these motions before her as well. Popok, I think, has the chance of backfiring because, as I've always said, her corruption is also matched and exceeded by her incompetence. Like when she tries to be corrupt, she often even applies the wrong legal standard. That's so obvious that Special Counsel Jack Smith just pulls out the seminal case on an issue and says, look, you're using the compelling interest standard. It's always been a good cause standard. You're just wrong, Cannon, in trying to help out Trump. She makes mistakes like that. So now you're going to have 10 motions, 25 pages, double spaced before her on these types of issues and expect that she's not going to make gross legal errors that could eventually lead to her ouster at the right time after Trump's already going to be potentially convicted on two separate felony cases, the New York State case and the Washington, D.C. case. And again, let me just make this final point too. Usually, criminal defendants don't like to just chill as criminal defendants, to your point, Popok, right? If they have a defense they think, I've got this great defense, I'm going to win, you file the motion to dismiss the indictment right away. You don't wait to the very last day of a deadline if your goal is anything other than delay. You want to be out of the case quicker. But again, to your point, that's never Donald Trump's goal here. He wants to delay this stuff indefinitely. We need to see what's going to happen with the United States Supreme Court, though, in the Washington, D.C. federal criminal case. They're taking their time on a very easy response to a petition for an application for stay pending certiorari that Trump filed when he lost the absolute presidential immunity argument before the D.C. Circuit. We're talking about what the Supreme Court should be doing. It's a one sentence, yes or no. And they've already had 2 Fridays where they hold their meetings. I spoke to Harry Litman on this, who clerked for 2 separate Supreme Court justices, who knows that process. He's like, you just go out and you say yes or no, basically. I want to get your take, Michael Popok, why it is we haven't heard from them. But let's take our last quick break of the show.
What you feed your dog goes a long way to helping them lead their best lives. Nom Nom delivers real, good food, backed by science to help your dog thrive, because everything from strong digestive and immune systems to high energy starts with what's in their bowl. Nom Nom delivers freshly made dog food with every portion personalized to your dog's needs, so you can bring out their best. Nom Nom's made with real, wholesome ingredients you can see and recognize without any additives or fillers that contribute to bloating and low energy. That's because Nom Nom uses the latest science and insights to make real, good food for dogs. Their nutrient-packed recipes are designed by board certified veterinary nutritionists, freshly made and shipped free to your door. Nom Nom's already delivered over 40 million meals to good dogs like yours, inspiring millions of clean bowls and tail wags. I feel so much better knowing that I'm giving my dog Lily better nutrition, and my dog really loves it too. Plus, Nom Nom comes with a money-back guarantee. If your dog's tail isn't wagging within 30 days, Nom Nom will refund your first order. No fillers, no nonsense. Go right now for 50% off your no-risk 2-week trial at trynom.com/legalaf. Spelled trynom.com/legalaf for 50% off. trynom.com/legalaf. Ever tried to break a bad habit and felt like you're climbing Mount Everest in flip-flops? Yeah, we've been there too. But here's a breath of fresh air. Fume. It's not about giving up. It's about switching up. Fume takes your bad habit and simply makes it better, healthier, and a whole lot more enjoyable. Fume is an innovative, award-winning flavored air device that does just that. Instead of vapor, Fume uses flavored air. Instead of electronics, Fume is completely natural. And instead of harmful chemicals, Fume uses delicious flavors. You get it. Instead of bad, Fume is good. It's a habit you're free to enjoy and makes replacing your bad habit easy. Your fume comes with an adjustable airflow dial and is designed with movable parts and magnets for fidgeting, giving your fingers a lot to do, which is helpful for de-stressing and anxiety while breaking your habit. The first time I tried fume, it was way more flavorful than I thought, and it feels very fresh. The look and feel of a fume is very sleek. It's well weighted, perfectly balanced, and extremely fun to fidget with. Plus, Fume's just released a magnetic stand for your fume, so there's no more losing it around the house. And it's built with fidgeting in mind. You can spin your fume around on it. Start the year off right with the good habit by going to tryfume.com/legalaf and getting the Journey Pack today. Fume is giving listeners of the show 10% off when they use my code LegalAF to help make starting the good habit that much easier. Start the good habit at tryfume.com/legalaf to save 10% off the Journey Pack today.
What great pro-democracy sponsors we have today. All great products, all great stuff. Check it out. In the description below, you have the links. You can click on them. You have the discount codes and everything there. So Michael Popok, we know that back in December already, federal judge Tanya Chutkan rejected Donald Trump's assertion of absolute presidential immunity. She denied his motion to dismiss the indictment there. And just so you all see the track that her case was moving on and what we previously talked about with Judge Aileen Cannon, the indictment before Judge Aileen Cannon happened before the indictment before Judge Tanya Chutkan. Donald Trump is first filing the motion to dismiss indictments before Judge Cannon. And back in December, he had already been denied those frivolous motions by Judge Tanya Chutkan, just so you have, you could think about the pacing there. So then he appealed to the D.C. Circuit Court of Appeals. He lost there. We got an order a few weeks back there. And then they gave him, I think it was until February 12th, to file an application for stay pending a petition for certiorari, meaning ask the Supreme Court to still keep everything paused, pending whether or not the Supreme Court will accept oral argument on this issue of absolute presidential immunity, which they can just reject as well. It requires 5 justices to grant the stay, 4 to grant certiorari. So if you're going to get the 5 votes to grant the stay, you'll probably then get the 4. It's kind of assumed under it that will then grant certiorari for the oral argument. So it's kind of an all or nothing proposition, Popok, as I see it. Either grant the stay and grant certiorari, or reject the stay and send this back to federal judge Tanya Chutkan. Now, it should be a relatively simple order on the stay. It's usually, they meet on Fridays, so their 2 Fridays have now passed since they've had full briefing. And usually what you'll get on that following Monday, and this past Monday was President's Day, I didn't see anything hit there, so I was thinking, okay, are we going to get a Tuesday? Is usually just a 1 sentence, stay granted through date X, submit further briefs, or stay denied, case, to be remanded or sent back to, the circuit court or back to the district court for further proceedings. We haven't heard anything. I want to get your take on what you think is going on here, Popok.
Yeah, I think you laid out the roads properly. I think it comes down to either they are using this time, and again, to us, it's silent, but behind the closed wooden doors, there's things going on. There's the caucus of the Supreme Court justices. The clerks are working behind the scenes. There could be memorandums that are being circulated to try to convince the hearts and minds of other people. There's coalescing of the 4 votes or the 5 votes, and then these pieces of paper that you talked about. There's really 2 reasons for the delay, and I'm hoping it's one. I'm cautiously optimistic that it's the one I'm going to say now, which is they're going to reject the stay. They're not going to require any further briefing. They're going to deny the appeal in this way and leave undisturbed the D.C. Court of Appeals decision that there is no presidential immunity, absolute immunity for criminal conduct as alleged in an indictment just because the person happened to be president at the time. But what the delay is that there's at least 2 people that want to be heard in their dissent. And what we're waiting on is not the one-liner. We're waiting on the dissents. And the dissents, God, if I was a betting man, I would just throw it out there as Sam Alito and Clarence Thomas either writing separate dissents or joining together in one. That takes a minute to write. No pun intended. These aren't minute orders. These are things that take a little bit. Usually these guys crank out 5, 10, 15 pages of a dissent, and then they might try to circulate that to try to change hearts and minds. And if things are looking bleak for them, and either the 4 votes needed to even consider an appeal or 5 for a stay, then it'll just be the dissent. They'll try to see if they can grab another vote over to them, which, if I had a guess, it could be Gorsuch. That's what I think they're working on. They're working on these dissents, which is a good thing, because that still means that if that happens, then the appeal, the stay, the interlock, all this stuff that's going on right now gets ended without further process, procedure, rigmarole, or oral argument, which would delay things another 30, 60, 90 days. And then it gets back to Judge Chutkan with a remand to get your trial back up and running. Within a day, she schedules a hearing, to a status conference, to bring the lawyers back in front of her and talk about the reset trial date, adding a couple of months on, because she said, just so we have laying the line in the sand, she's already on record as saying that 7 months is good for preparation. It's enough due process time for Donald Trump. Now, she told him, this is where they can, because the lawyers for Donald Trump are not, how do I put this? They're not the best lawyers in town, and they're not consistent with each other, and they're not monolithic. And sometimes one lawyer says something that undermines the arguments of another lawyer representing Donald Trump in a companion case. So Chutkan and the D.C. Court of Appeals both told Donald Trump, you do not have to be working on preparing for your trial in the D.C. election case. We don't expect that you're still working on it. You shouldn't be working on it. You've said it's a burden. We're going to take the burden away for you on the stay. And so Chutkan has taken that position. And he was about 5 months into prep. So my gut is she would add 2 more months and take us into June-ish, July, which was going to be her holiday. And then we get this trial, which will only take 4 to 6 weeks, up and running and done and in the can with a jury verdict prior to the election. The reason I said that there was already Trump's undercut his own argument is, I don't know if you caught this, but Todd Blanche, the lawyer for Donald Trump, told Judge Merchan in the New York Supreme Court case that's going to trial March 25th that they have been working on the DC election interference case, regardless of the stay, as an argument as to why he shouldn't have to gear up now for a March 25th trial in Stormy Daniels, because they didn't think that was ever possible, which is bizarre, because Blanche was in the courtroom when the judge told him, I don't care about your primary season. We're picking a hard date, and here it is. It's March 25th. So, but in arguing that, he also undercut the argument, and I'm sure Jack Smith's going to bring to the attention of Judge Chutkan, if it ever gets back to her, they've been working. You don't have to give them much more time. Blanche just said they've been working on the trial as if they thought it was going. And so let's get this trial up and running as fast as possible. It's either what I just described, that we're waiting on dissents only, and the D.C. Court of Appeals case is going to be the ruling. And if Trump's got an issue, he can take it up after he's convicted, we hope, and after an appeal at the end of a case, like anybody else, like any other regular defendant. Or they're struggling, as we saw, when you and I were trying to figure out what is taking the D.C. Court of Appeals so long to do their which, by the way, 4 weeks to wait on an opinion that turned out to be, 68 or 70 pages of really hard-hitting, perfect analysis was not really that long, but we were getting impatient, obviously, for obvious reasons. But that the reason for that is, you could tell they were trying to coalesce around and to get a complete unanimous decision. And if there were any holdouts, they were working through that, as only judges can, in circulating drafts of opinions until they got a coherent decision that all 3 could join onto. So it's either what I just said on dissents, or there's still lobbying going on to find a 4 to take the appeal and or the 5 for the stay, and that is what's going on behind the scenes. But as a betting man, I think they're going to keep the D.C. Court of Appeals decision in place on the immunity. They're still considering, we haven't gotten the ruling yet there, the ballot banning 14th Amendment Section 3 case that you talked about earlier. I think they maybe At the same time, they let him be on the ballot, but they leave the absolute immunity thing in place to allow the trial to happen before November. And we'll just have to see if we're right. When we see dissents, we know I was right or we were right. And if we don't see dissents and we see something else, then they were working on something else.
Look, it is possible, though, that there are dissents that go in the opposite direction, where the court grants the stay and accepts certiorari, and then you have dissents explaining why the D.C. Circuit opinion made sense. Although, why that's probably less likely is you would be delaying and holding up the inevitable anyway. And if you were going to write that dissent, unless it was super kind of quick and concise, you're kind of lending to the delay. So why even do that, just rather than say you respectfully dissent? So that's why, Popok, I think yours is, more likely, because rejecting the stay has a little bit more of a dispositive impact than accepting the stay in terms of what would encourage kind of a lengthy, unusual dissent in the circumstance. But again, what we're trying to do right here is the equivalent, to use the example we've given before, of tracking the weather patterns the way a meteorologist does to tell you if it's going to, snow, or if it's going to rain, or if there's going to be sunshine. And you don't always get it right, but we can look at those data points and share with you how we go through the data to try to make these predictions. I want to talk about this IVF ruling. I don't want to have a whole lengthy discussion on it. We've covered it elsewhere, and we're going to have other coverage on it as well. But I think it's important that we address it here on Legal AF. And Michael Popok, I know this also has a personal element to you that you and I had discussed before the show. And just, if everybody doesn't know what the ruling is, it's that this MAGA Republican stacked Alabama state Supreme Court ruled that frozen embryos are the same as children, and thus an IVF clinic can be charged with wrongful death if any of the frozen embryos are destroyed, the same type of wrongful death charge as if a child or other human being was killed. So in response, IVF clinics said, look, if there's any issue ever with a frozen embryo that gets destroyed, or or something happens to it, even through the regular process of providing clinical services, we could be charged with murder or wrongful death, and we can't operate. It's impossible for us to operate. These are the types of decisions that we have to, in one of the examples of the cases before the Alabama Supreme Court, it involved another patient kind of getting into a room and destroying something. But outside of the patient destroying a frozen embryo, another patient destroying a frozen embryo, every day as part of the clinical services, there are decisions about, okay, are there 10 frozen embryos, and how to maintain the frozen embryos? What do you do if there is a birth? What do you do if there isn't a birth? And if you're going to be charged with murder for every one of those decisions, and then you can extrapolate these kind of RICO cases, if you will, wrongful death, murder type RICO cases, where everybody in the clinic, from the secretary all the way up to the CEO to all of the doctors, are getting charged with murder, as well as potentially even the patients themselves being charged with murder, then you can't function. And this is not something that happened out of nowhere. This is actually what people who were having all the warnings about, if you overturn Roe v. Wade, this is going to happen. And this is what happened. I understand right now there are a lot of Republicans out there who are now trying to act like this wasn't their position, but it was their position. They put judges who believe this way. It's intentional. And then when what happened ultimately is what they wanted, they then act like they're the firefighters when they were actually the arsonists, and now they want to put out their own fire. Some of them are applauding this ruling, but this is a predictable ruling based on the overturning of Roe v. Wade, because if you had Roe v. Wade in place, you could never have such a declaration as the one here, that a frozen embryo is basically given the same rights as a child, and that stems from overturning Roe v. Wade. Popok, I want you to share your thoughts as we close out this episode.
Yeah, it's no secret that my wife and I used IVF. We're just coincidentally, my wife's pregnant not through IVF, but we are big supporters of it. And under the Alabama law, because we made a decision with our medical provider that 2 of 6 of our embryos were not viable, I could be charged apparently with wrongful death and or murder in the state of Alabama. For a party that claims to be pro-family, they are the exact opposite. And everything, as you said, Ben, that they've done has led us to this moment as a natural extension. There's no difference between Josh Hawley calling embryos extrauterine children, calling them unborn children. Listen to the language of the right to life movement, as they like to call themselves, and them not understanding the difference between an embryo, a fetus, and a child, and the live, already born parents who are supposed to be making decisions about the most intimate affairs of their life. And as you said, Ben, when you put on in Alabama, there was one woman justice there, and there was one dissent. I think it was one dissent, and the Chief Justice in his concurrence talked about everything that was just ripped from the Bible, that these embryonic entities have the face of God imprinted on them. This is actually in a legal analysis made by the Chief Judge of Alabama. And then they wonder, after they found that the person, and I never really got to the bottom, maybe you know that you can tell me offline or here, I never found out why that patient was wandering around the embryonic nursery, knocking over test tubes or whatever they're contained in. But they said, oh, well, for the 3 couples that lost embryos, they can sue that person for wrongful death because we find that they are children, or as Nikki Haley likes to call them, they're babies. Embryos are babies too, when they are not. But the natural extension of that may have not have been clear to Sam Alito, who wrote the Dobbs decision overturning Roe versus Wade, putting it into the hands of states. By the way, 12 of which, now including Alabama, believe that personhood starts at the embryonic period, embryonic moment, which is, you see where this is going. The fact that they may not have considered that the very next day, the University of Alabama would stop all IVF treatment. Okay. And I can't even, my heart goes out to the families that were in the middle of a transfer or were in the middle of the process, and this is their last hope for children. And now in Alabama, the lawyers and doctors saw the writing on the wall immediately from the Alabama decision. And this goes back to the heartlessness of the Republican Party, to be frank, especially when it comes to women and family. When Sam Alito said, in ripping away a woman's constitutional right to choose after 50 years, enshrined in the U.S. Constitution through Roe versus Wade, and a line of other cases, not just Roe versus Wade, that led us to that moment about reproductive rights and privacy. When he said, basically, as only a old white male who never born a child can say, it's not for us to worry about what happens. It's a states' rights issue. Each state should decide whether they're going to have a constitutional or other right for a woman to choose, but it's not anywhere in the Constitution, and it was wrong the day it was written, and it's wrong now, and we're finally going to fix this historical wrong once and for all, and leave it to the states and let them do it, and we can't be concerned about what happens. Really? Now you're watching the mad scramble. I mean, if it wasn't so tragic, I'd be laughing over it, about watching politicians in Alabama and on the national stage trying to figure out how they can both be pro-family and also allow somebody who inadvertently or intentionally terminates an embryo because of non-viability or other reasons, why they should be charged with murder or wrongful death. This is the problem of the party, because their morals and law are not they don't intersect properly. And so when you, like, as you said, when these movements led by the Josh Hawleys of the world and all the other right wingers try, what you get is what you got here, which is a judiciary in Alabama that now has codified this right to life movement and come out with decisions like embryos or babies. And now what I'm hoping is that they'll never be able to fix it fast enough. And this will then be another wedge issue that the Democrats need, along with the Dobbs decision, to animate and motivate their base and get them to the polls for Joe Biden. And the fortunate thing is, every time, and I've said this on one of my other hot takes, and I think midweek, polling is one thing. I mean, you and I could do whole hot takes, and we have, about where the polls are at any given moment. But that's not voting. Voting is not polling. And every time the American people have had a binary choice, thumbs up or thumbs down, since including the midterms, it's been in favor of the Democratic agenda and Joe Biden. Every special election that's mattered, every ruling related to women's rights that matters, have all gone our way since the presidential election. That is what I look for electoral success in November, not this handicapping of how many points up or down Joe Biden is in any given moment.
Look, I think my hope is that there is, a legislative solution quickly to this crisis that was created by Republicans. But I also still, firmly want people to have all of the data and realize that there was all of this legislation, like the Life at Conception Act and various iterations of these bills that had been working their way through the House of Representatives that MAGA Republicans had always signed on to. Like this was their position. And now the same people who affix their names to these bills are saying that they actually, they want to fix it. Y'all created the issue. Y'all are the arsonists. That's the issue. And there's so many issues like that where they start the fire and then try to create chaos, and in a very predatory way, try to prey on people's vulnerabilities with the chaos and harm that they created. And that's why it's just important that we get out the raw data. We just let people know what's up. I mean, where do you stand? Here are the issues. Here are the facts. Here are the data. Here's the data. Make educated decisions based on that. And that's what we stand for here at Legal AF. That's what we stand for here at the Meidas Touch Network. And that's what we know you stand for as members of the Meidas Mighty and Legal AFers. Thank you so much for watching this episode. You can sign up for our newsletter at MeidasTouch.com/newsletter. It's free to sign up for the newsletter. You'll get at least a daily email from me, my brothers, or our editorial team with breaking news and other news from MeidasTouch.com. Check out the newsletter right there. Special thanks to all of our pro-democracy sponsors. Once again, those discount codes are in the descriptions below. Thank you to everybody who signed up for a YouTube membership and gifted those YouTube memberships. I love seeing all of those emojis. And we're not funded by outside investors, so it's a fun way to grow this independent media platform through the emojis with our pro-democracy sponsors and in other ways like that. Thank you all so much. We'll see you next week on Legal AF. Shout out to the Meidas Mighty.